Smita Kapoor, member of Compact. Welcome to this technical session, which is a very, very interesting issue. Basically, this is the discussions here. I have a very distinguished panel. I'll ask them to introduce themselves. But the discussions are going to be focused on three issues: compliance, leniency, and settlement. There's a difference between leniency and settlement, and I would request my distinguished panelists here to bring out that distinction between the leniency and settlement process. And let's first start by introducing the panelists introducing themselves. Let me start from my right. You all know Mr. Chandyo, who's going to be the moderator for this session. Let's start with Mr. Nitin.
Good afternoon. I'm Nitin Gupta. I'm Director General with CCI. For the last 1 year, I'm an IRS officer of 1986 batch.
Good afternoon. I'm Smita Chigran. Can you hear me?
Yes.
I'm Smita Chigran. I'm the Secretary of the Competition Commission. I joined this post in February 2013, and just as Nitin said, I'm also from the 86 batch of the IRS.
Good afternoon, ladies and gentlemen. My name is Peter Komasoska. I'm a German national. I'm Brussels-based. I deal exclusively with EU and national competition law in Europe. I focus in my practice on what I call competitor interaction, which can cover nice things such as mergers and acquisitions, and somewhat trickier things, if I think about the people on the right side of me on this panel, when you turn to information exchanges, price signaling, cartels, and whatnot, at the regulatory level as well as at the litigation level when we turn regulatory process into civil damages.
Good afternoon, ladies and gentlemen. I'm Andrew Foster from Skadden Arps. I am in our international competition group, which has offices in the U.S., in Brussels, in Europe, and also in Beijing. I have worked in all of those jurisdictions, handling, as Peter says, both friendly and unfriendly competitor contact. Our focus is not only on merger control, but we also do global cross-border cartel work, which involves first and foremost the compliance programs to prevent having to have those issues, and then in addition leniency programs when the compliance programs cannot catch everything, and eventually settlement when that's appropriate as well.
Good afternoon, ladies and gentlemen. I'm Sundar Ramanath, partner with Lakshmi Kumar and Sridhar. I am a general commercial litigating lawyer, but with an interest in competition law, so that's why you find me on the panel. Thank you.
Okay, like I said, we have three main topics. Compliance. Now, compliance has two phases. Compliance from the side of the enterprises by individuals. Compliance enforcement from the side of the regulator, the Competition Commission, and to some extent Compact. And how the compliance programs work will also determine how the leniency program works. Under the Indian competition law, you have a leniency regulation issued in terms of the power vested with the Competition Commission under Section 46 of the Competition Commission Act. But this leniency regulation deals only with the cartel situations. You don't have any leniency regulations in regard to dominance, abuse of dominance. You don't have any leniency regulation or any kind of violation of reporting, etc. for mergers and acquisitions. And internationally also it appears that the leniency programs are primarily targeted on cartels. But you do have issues arising which require some kind of a different approach than the normal regulatory strong arm approach of enforcing the law through penal action, cease and desist actions, or in the case of merger, human laundering, division of enterprises, for dominance, etc., etc. So when you look at the Indian statute, like I said, you have a provision in the Act for leniency, for reducing the penalty, and you have a provision in the regulations. But there was a Madras High Court judgment which said that in the section 27G of the Competition Act, there is a power to settle with the Commission. And the case was set aside to the Commission because there the informant in the opposite party had come to a settlement between themselves and they wanted the stamp of the court for the approval of the settlement. And the High Court very rightly observed that the power of the Commission is not restricted only to individual, is actually not only for individuals. The power has to be where the public interest is to be exercised, where public interest is involved. So that is another facet of looking at settlements under and not as so explicit a law as it is there in some other jurisdictions, and leniency program and its operation under the Indian system. As of now, though the regulations are of 2009, I'm told there are a lot of applications filed, but not a single decision has come from the Commission till now, but it would involve a lot of examination, understanding, before they can finally issue at least the initial few findings of theirs. So I would request my three panelists to first give their opening remarks on these three issues which we have flagged, and then we'll open up the discussion among the panelists. Each of them brings a different kind of a perspective. In fact, my colleagues from overseas, one was saying he's an expert in the EU area, other one is bringing his experience from the US jurisdiction, and then Mr. Sundar, is from the Indian, he has expertise in the Indian competition. And then we have the two representatives from the regulators. And I would request them not to confine their views only to what the regulators view as per the current law is. I would expect them to also discuss and kind of flag issues which they think should be covered under the law and are presently either not there or are not receiving adequate attention. So shall we start with Dr. Peter? And now I'll let the moderator take over after their done the introductory remarks.
So how shall we do this? Is there a topic you want to start with? Maybe compliance or?
Peter, if you, yes, why don't you start with sort of giving us a flavor of compliance? Actually, maybe if I can switch to Andrew. Andrew, we heard this morning. Okay, thank you. So in the morning we heard our chairman talk about the 66 programs or policy programs that the CCI has been involved in, and of course those are directed towards moving towards enforcement to education and understanding how competition law is being enforced in the country, how it has changed the rules of the game. So we've been long advising across jurisdictions on companies, especially newer economies such as China as well, on how do economic actors were to act within the confines of the law. So could you just take us through the processes and some of the challenges that you may have faced in rolling out the compliance programs across all these jurisdictions?
Sure. Well, for these introductory remarks, I will focus on initially the compliance program from the perspective of the who is our client of the economic undertaking that's working, there is a very different and equally important perspective of compliance from a regulatory chair, and I think we will get to that as well as we speak. But to focus on how to use these compliance programs for businesses is very important, because the key, even to begin from the regulatory thought process, the key to a compliance program is, of course, first and foremost, to prevent the anti-competitive acts from ever occurring, but especially in jurisdictions where you don't have as established a competition law that has been spread out and propagated throughout the country, compliance programs actually can play an enormously important role in terms of education and in terms of teaching the countrymen about the importance of the law. And that is something that is vital in terms, again, just from a first principle, is vital in terms of conserving the scarce resources for a regulator that is not as experienced with dealing with cartel law, or cartel law does not have the long history it may have in certain jurisdictions. And so Karen mentioned, especially in China, the competition law has been in effect only for 8 years. And prior to that, there is no cultural understanding of competition law. There's no understanding about what is right, what is wrong, or what the fine lines may be in that sort of behavior. And so compliance programs play a very important role for these companies, because in part, one of the reasons that they should be encouraged from the regulators, because they really do teach about what the law is, and in a way that you simply won't have the ability to do. You have a small number of regulatory people who are responsible for reviewing merger control, responsible for reviewing cartels, responsible for abuse of dominance, responsible for everything that's going on. Education is something that sometimes can be hard to do. So you can see that these compliance programs have a great good if you can get them instituted. And often the challenge is to convince companies why they should institute, right? Because it seems, certainly from the lawyer's point of view, and perhaps from the regulator's point of view, that it should be self-evident that compliance programs are great and everybody should want to have them. But it's important to remember that every single thing that is done at a company level has an equivalent time cost, it has an equivalent money cost. You have to convince the company it needs to pay lawyers to teach and to educate in this way. And it can be hard to sell people on the benefits of that, especially in a situation where people don't necessarily understand a relatively new competition law, or one that's being enforced in a relatively new way. So some of the things that we have really tried to emphasize and find that it's necessary to explain to companies is, the main thing that gets people's attention is to really focus on dollars, right, on the potential penalties in the first place. And that's something that's easy to focus on, and something that people, I think, who may not be familiar with U.S. or European law may not find to be, again, find to be self-evident. We often see companies that are very surprised when we tell them, if you are selling a product that somehow touches on the U.S. economy, you may well be liable there. I think many people know that you can be thrown in jail in the U.S. Many people know that there are these substantial fines in the U.S., but most people think, oh, well, we don't have a subsidiary there, or we only sell within China, so there's no reason for us to worry about those penalties. So the first thing we have to explain is, if you are participating in the stream of commerce and doing things that have a direct, substantial, and foreseeable effect on economies outside of your own, you need to be prepared that you may be subject to laws not only in your own country, but from across the world, and they may have far different and far greater penalties. One of the things that's helpful in explaining that is there really are recently some very eye-opening penalties that have been happening for competition law. Within the last 4 years, I think the European Commission has levied fines of 8.7 billion euro collectively on companies. This year alone, Daimler had a fine of 1 billion euro levied on it, and DAF 753 million. So when you start to put those statistics out, that's the way that you can begin to convince companies they need to adopt these sorts of things. And you see that's where the regulatory good of both compliance and education flow.
Thank you, Arjun. One of the comments that you made was regards to looking beyond your own borders and how that can affect. Sundar, is this a one-size-fits-all approach, or when you counsel Indian clients, what are the challenges and what are the questions sometimes that they ask?
Thanks, Karan. Before I start on your question, what I probably thought was the theme is on competition compliance. The issue really is, do we take compliance seriously as a country? I think that's the foremost question that we need to address right at the outset. Honestly, myself included, when I was told that I need to speak on compliance, I said, wow, compliance, we're going to talk on that. But that's the kind of attitude I had. I thought probably I was biased. I thought let me probably reach out to a few directors of companies, legal counsels, and see what is their view on competition compliance. So we had a small data from 21 companies that reached out last afternoon. 10 large Indian companies, few who have also been investigated by the Competition Commission, and 11 companies were foreign MNCs subsidiaries, and try to understand if they have actually put in place a competition compliance program. And I wasn't surprised with the results that I got back on the kind of responses, the answers I got. Out of the 21 companies that I reached out to, and most of them were, the persons I spoke to were either the legal heads or the directors in companies. And out of the 10 Indian companies, only one had a competition compliance program in place. And all these companies are companies that you look at in the newspapers or in television channels on a daily basis. So one. And in that case also, they just had a compliance program for the top management. That's about it. Out of the foreign subsidiaries, I thought there were 6 out of 11, and 4 who didn't have a compliance program. And one interestingly told me that he had to check and come back. So I thought that was very interesting, the kind of data that I was looking at, that as a nation, do we really take compliance seriously? Because the Commission has been taking out a lot of information, they're rolling out the compliance programs now, they're asking people to come and take compliance sessions. But as a nation, I generally feel we never take compliance seriously. So I thought, what could be the reasons why we really don't take compliance seriously? I thought, one, cost is a key issue for most Indian companies. Do we really want to incur substantial sums of money on a competition compliance program, and also investing in resources? Because most Indian companies don't have a very big legal team, unlike the foreign companies, they don't have separate teams with antitrust and other separate areas. So one is cost and utilizing resources for competition companies. And 2, more important I thought, was culture. When I spoke to the legal counsel, they said whenever we get a particular issue in competition law, we reach out to the counsels. So when a problem does reach the legal counsel's table, he sits up and decides to approach a lawyer. So as a nation, I think we look at handling an issue when it comes to us instead of looking at beforehand. Of course, as Andrew mentioned, there are a lot of advantages we are all aware of running out a competition compliance program. Mitigating penalties, avoiding penalties, reputation risks can be avoided, shareholder value, a lot of advantages that we do have. But I do believe that 2 key issues need to be addressed: cost and culture. And probably over the course of the discussion, I can probably speak on what are the steps that the Commission and also stakeholders like lawyers and law firms can take as part of ensuring that compliance is imbibed into our DNA.
Can I ask you to first give your opening remarks and also address the second big topic on our agenda today, which is leniency and the CCI's leniency program?
Thanks, Karan. So So I think Sundar just spoke about the competition compliance, and one realized how very few corporates in India actually have a competition compliance program. Let me share a small thing with the House here today. One of our leniency applicants actually, in fact a couple of them, have pointed out to us that it is because of their in-house competition compliance programs that they were able to unearth the existence of a cartel. And then they came to us with leniency applications. So maybe Sundar got in touch with some very top 10 or maybe whatever, where only one was having a competition compliance program. But it is indicative that probably there isn't enough that is done in this end.
I will just clarify, it was of the pure Indian companies. MNCs, I found the data to be better, 6 out of 11. But when you look at pure Indian companies, who have Indian promoters, traditional Indian companies, that I found is wrong. Which is bad.
So obviously compliance leads us to leniency, and let me talk a little bit more on leniency, because I think the other panelists would speak more on the compliance part of it. And as far as leniency goes, we all know that it's very difficult to crack hardcore cartels today. It's increasingly becoming difficult to find the smoking gun. And so what you would be looking at is leniency applicants. We had a few officials from the US FTC and the DOJ who came a couple of months back to the CCI for a certain workshop. And they shared with us one statistic. They said more than 90% of the cartel investigations in the US emanate from leniency applications. So, and that's why they have a high success rate. There are other reasons also for that success rate, which I will probably come to later. But that is very important. This sort of culture is still to come in our country. But let me say one thing, that it's increasing, fast increasing. In my introduction, I had said that I joined in February 2013, and soon after that, we had the first leniency application in the CCI. Thereafter, let me share with the House that we've had a number of leniency applications. These involve leniency applicants who were parts of international cartels and home cartels also. They cover various sectors. I also want to share that these are not all of them are cases where they are the ones who assisted the CCI to form a prima facie case. That is, we had no clue about the cartel, and since the applicant came to us, the LP applicant is the one who enabled us to form a prima facie case regarding the cartel. In addition, we have other applicants who have come to us in course of the DGA investigations. You all know that as per the regulation, provisor to regulation 4, I think, you are allowed to come in if there is a cartel investigation on. The applicants, the participants of the cartels can come to us and file a leniency application anytime before the DG presents his report. So we've had both these kind of leniencies. In the mature jurisdictions, they call it the type A, type 1 and type 2 types, but we don't call it. We just say leniency applications under the regulation or provisor to the regulation. That is before the prima facie or on an ongoing investigation. Just to bring home the fact that we have leniency applications of all types. The profile is varied. Since I find lots of people in this room who are hands-on, they would know that you can make an oral contact, email, phone call, and we note down in the secretariat, we note down the time of the call, the date, etc., date, time, etc. And we move the file for a marker, we bring it before the commission, and our regulations allow, the lesser penalty regulations, allow 3 markers. The first marker is to the first applicant, the first to the door, who gets and can get a leniency up to 100%. The second and third, it's 50% and 30%, up to 50%, up to 30%. This is quite unlike, say, the US, where there is only one marker who gets 100%, period. There is nothing like up to 100. So that is because if I go to substantive section, that is section 46, there are 3 important words over there. It's full, true, and vital. And so you have to make a full and a true disclosure and a vital disclosure. Interestingly, the section doesn't discriminate between the first, second, and third applicant. That means the full, true and vital applies to all three, all the people who come, first in line, second in line, third in line. It is the regulations who then say there's a first marker, second marker, third marker. And for the second and third marker, the additional words that are used are substantial value added. So it's not just value added, it has to be substantial value added. So that is the basic architecture about markers. Once we give the marker, we're given a 15-day window to actually come up and give details about the leniency application that you made. And that details are listed as per the schedule to the disciplinary applications. Here, let me just share with you a small practical difficulty that we face. And maybe in the earlier applications, those were early days, and the kind of information that came up to us, we did form certain prima facie orders were passed, and in 26 months investigations were directed. But probably they were in the process of culling out that information, and it was kind of half-baked. So the DG is now grappling with those issues, because what has happened is that the leniency participant, then the leniency applicant says, okay, I've got my first leniency marker. I've enabled you to frame the 26 order, and so now that's it, I don't have anything more. But probably what we need to go back is to the Act, is that the Act also talks of continuous cooperation, which is very essential to the markers. So marker is a very, very sort of a provisional position. Finally, when it comes back and the DG report comes to the Commission, all of this would be evaluated. So it's very important for the leniency applicants to be very responsible in the entire process. So that's the issue of the markers. And Karan, you had asked me to also speak about confidentiality and inspections. So if I have crossed my time, maybe I'll leave that for later.
Maybe in the next slide. Thank you. Mr. Gupta, from the perspective again on the topic of leniency, you were entrusted with the tough job of detecting all these cartels after the CCI has already given its view that there's a chance of case. How has, in your addressing of the remarks, from the investigator's point of view, and how the leniency program in the abroad should work?
Thanks, Karan. The first thing which Peter has discussed is the compliance. And if I start with the compliance part, that competition compliance program undertaken by any organization would be very useful for developing a case by that organization itself as a leniency petitioner in case there is a detection of contravention of the law. So the uses, the benefits of the compliance program vis-a-vis the costs which it can incur could be huge. Our law is nascent, the decisions are coming up, and the quantum of penalties are still uncertain. As of now, these are huge, but we don't know what the Supreme Court will ultimately hold. But if the penalties perceived are really high, the international experience which I have read is that it helps in developing a better compliance program. So having said so, and with the new Companies Act coming into play, where the fines imposed upon the companies or directors make them ineligible for, in the light of the Schedule 5 of the Companies Act, New Companies Act 2013. So I believe that the competition compliance program by the corporates and big firms is very, very important. Otherwise, this liability on the directors would be huge. So, in this perspective, it's important for the corporates to follow the competition compliance program. Now, if I come up to the LP cases which we are pursuing, I can't divulge more, but I can say that we have, like Smita has told, that we have a large cross-section of cases. involving international cartel as well as the domestic cartels. Our experience has been very good so far. We have moved a lot in several cases. I believe that once we start more downgrades and all that, the leniency cases may increase in due course of time. So the importance as of now which we perceive is that how fast can we move and close the cases which we have at our end successfully, means in the sense that it is taken to the logical conclusion and end, which I believe can be taken in due course of time. Several issues are, procedural challenges are coming up in the way. Probably we can discuss it at a later stage, but there is a direct relationship between the compliance program and leniency, which is very important.
Thank you. Peter, last but not the least, could I ask you to speak on settlements, and also in your opening remarks, if you could specifically address why the European Commission or the legislatures in Europe thought it fit to have a settlement procedure and the philosophy behind it.
Thank you, Grant. So we really have two systems in place. We have the Article 9 commitment procedure, which I'll say very little about, which we have in place for our regulator at EU level to, well, effectively negotiate endings of infringements of Article 101 and 102 to regular commitment process for dominance cases and general conduct cases. What I would like to focus on today is our special system for cartel settlements, so settlements in cartel investigations, which is the subject of a specialized notice which was issued in 2008. This process took 2 years to lead to the first decision. And by that time, I think the vast majority of the commentators, and I must say, I need to be very, very cautious in what I say here, as with Professor Bush in the audience, we have a very learned, if not the most learned, connoisseur of European competition law in the House. But around that time, people thought, what a dud, this new program. Look at it, 2 years down the road, nothing has happened. I think, meanwhile, it's been turned into a complete success story, at least from the regulatory perspective. Over 50% of all cartel cases these days get settled. So this system really works well. Now, is this some sort of aggressive plea bargaining? I'll pick out as a regulator one company, squeeze it to bits, and then take all that information for a good price and go to the next company. No, it is not. It's actually quite a modest program, but a program which I think, with some arrogance for which I apologize, might be of interest to an emerging and very active regulator like we have here in India, for the following reason, if you let me explain that statement. When our legislative powers were considering what sort, if and what sort of settlement system would be of relevance for European cartel investigations, there was a lot of initial, what I think is best described as just, objection. And the real objection was, well, if you have an infringement, which is established, and it's a hardcore infringement, a cartel infringement, you cannot possibly have administrators negotiate. I mean, it's an infringement. So if it's an infringement, you get fined. And you cannot give the power to these non-elected people to weigh, sort of like in the US, how to say take investigative advantage of the powers you've been allotted. Instead, we came up with a program that's best described as one that is focused on, quote unquote, procedural efficiency. So the way it works in Europe is we have a separate leniency program Our leniency program, if you'd allow me to comment, is clearly even more successful than the US one, because I think in a recent conference, someone from the Commission said, well, we had 20, the last 20 decisions, 19 were the result of leniency applications. And that is not saying that that last one, number 20, was the result, I believe, of a merger filing, which then led to an investigation. So leniency is a great program, but it's entirely separate. So either the Commission does its own investigation and practice, assisted by the leniency applicants under a leniency notice, and somewhere around the end of that process, what would normally happen? Well, the Commission would issue what we call the Statement of Objections, our version of the indictment in the US. Instead, under this new program, at around that stage, before the SO, the Statement of Objections, has been issued, the Commission can approach the parties if it deems it fit. Very important, it's a Commission's initiative, and say, how do you feel about settlement? And then either the parties say, well, not at all, thank you very much. More often than not, they'll say, well, it's very interesting. How does it then work? Well, you then diverge from the regular process. Here's the SO, you reply to it, we issue the decision, where instead you have, without prejudice, discussions with the regulators, really in 3 steps. First step, regulator in an oral session, one party after the other, but for all parties, we have a one-size-fits-all system, sets out its case. Parties then return to their closets, consider that case, and then there is a second meeting, again, one for each company under investigation, where a company presents its reaction to the case that the regulator has set out. Third meeting, well, you either agree to settle or not. Once that's done, and of course this is slightly oversimplifying all the little steps that go in between the big 3 steps, the Commission then issues a RUMP SO, a very short Statement of Objections, to which the parties issue a pro forma reply, as is foreseen in our regular process, and then there is a decision. Well, you would say, why would anyone want to settle? What's in it? Well, for the EU, what's in it is very simple. Massive savings in terms of time and resources. There have been hardly any appeals, and this is why when I called this program one that is geared for achieving procedural efficiencies, there have been hardly any appeals. Appeals are no fun for the regulator, because finally, after years of trawling through all the data, you have a decision and then you can do the whole thing again before the courts. It's easy to see why the Commission would like that. What's in it for the parties? Well, formally, you get 10% off. So it's independent of leniency, where we have a different system, where you get much bigger reductions. You get 10% off in addition to whatever other reductions you would have. The final fine as will be defined. Well, that's a bit thin, you might think. What else is in there for the parties? And this is where it gets a little tricky, because it isn't quite in the system. The settlement discussions, although the Commission holds all the strings, and although the Commission can terminate at any time, they are also an opportunity for the parties to reduce, I wouldn't say the core of the infringement. The Commission has done its investigation. There's clear guidance. This is not to be a negotiation. But as in every investigation, there are those facts which are crystal clear, and there are those facts which are maybe on the fringes, or where for certain companies maybe they weren't involved in that particular product, or where it isn't entirely clear that they were involved for the whole period. There are opportunities to reduce somewhat the product scope or the timing scope. And the way our fines are set, it's all about how long you were in it for what. So there are certain informal advantages. I would not oversell them, but they're there. But there's also one, and this is a slightly controversial point, there is obviously one disadvantage, or at least one point one should never forget or lose sight of. If, as a company, you agree to settle, at the end of the run, the commission is still going to issue a formal decision finding you are a cartelist. It may be a shorter decision, but you're still found to have infringed 101 under hardcore infringement rules that are a cartel. So, civil plaintiffs can and will come after you, frankly, just as much as under any regular process. So I think all things equal, it's a great system. It's part of a wider system. It's not a standalone. It works well. One shouldn't oversell it, but it works sufficiently well that now, if I understand our colleagues at the European Commission correctly, they are looking to expand it somewhat in scope and liability. So I think that's a quick run through.
I just wanted to make a point here. The civil action part and the leniency program in India. The leniency program is mounted by, as per Act, by the Competition Commission. But